Guilty. Guilty, guilty, and guilty. I want to bring on a very special guest right now, Prosecutor Latonia Hines, to talk more about what we just saw. Latonia, welcome. Good morning to you. And I'm curious, just let's start from the right, what you saw, reaction to that verdict.
I think it was a just verdict. I think that some people were worried that there would be this issue that the jurors would have a problem being able to say that he was truly responsible for the death of his child. But I think what we look at is this, because I will have to give the defense some credit. They had this, they did a good job dealing with the timeline of when the child actually died, but the neglect could not be taken away. The neglect of this poor child, and that evidence, I think, was very powerful. So I'm not surprised by this verdict.
Were you surprised that they didn't want to poll the jury?
Now, that I am surprised about. That is one thing that usually always happens. Always are going to go, at least as a defense attorney, is poll the jury.
Why wouldn't they do it?
Say it again?
Why wouldn't they do it? Why wouldn't they ask to poll the jury?
I don't understand that, because especially when you're getting ready for purposes of appeal, you're always thinking about all types of issues. You want to make sure that every person on that jury, this was the verdict that they wanted. This is clear. They were an influence. This was their jury. And it's a powerful thing, too. It makes jurors have to stand up and say, yes, this is my verdict, true verdict. So I'm not really sure what the defense thought process was about it. Maybe they were just stunned, but I've never really seen in this type of case where a defense would not, after a guilty verdict, say, I would like to poll the jury.
Well, look, there's a lot that we can't forget from this case, and one of the things that I know the jury definitely listened to and probably will not forget is the prosecution's closing argument. And if in case you missed it, take a look at this. It's something to watch. That was some of the prosecution's closing argument in the Zachary Koehn case. I'm back here with Latonia Hines to break it down. And Latonia, when you listen to that, I'm curious, this is not a classic first-degree murder, premeditated case where he thought, deliberated on killing his son. No, what they need to prove is failure to provide critical care here. And is that a tricky case? And I'm curious how you think the prosecution did summarizing it, both in their opening statement during the trial phase, their closing statement, their closing argument, and now in their closing argument here in the penalty phase.
It is very tricky, because what you're basically showing is omission. And usually when people think of a death, they think that you had to have done something. Like she said, you would have had to do like a battery, something physical. But what I thought was excellent, because I thought in the beginning, it's very clinical when you're trying to start off a case if you're the prosecutor. I thought that the ending was more powerful than anything, because what she laid out for the jurors to see is like, every time, and the jurors can think to themselves, every time you went in the house, you made a choice not to feed this child, not to do these things for the child. You take the time to go and do things for yourself, but you, by your not doing something, it was doing something. And I think that was extremely powerful. When she went over all the different things and all the different times this father could have been doing something to help his child, I thought it was magnificent.
The idea there, really, that he is a father of three, right? And I really want to talk about Nala. That was his daughter who was in the house. She was okay. The dog was okay. That's something that the prosecution stressed about him under cross-examination. Do you think that's what did him in a way, is the fact that you had all these other fine individuals in the house who were okay, but Sterling was in an 81-degree room and was dying in his own filth?
Yes, absolutely. What human being would not feel the emotional strings when you see that the choices were made? Even though it's an act of omission, as we call it in the legal terms, it's mean that you didn't do something, but the choices were made. You took care of your daughter. You took care of a dog better than you did one of your other children. That is absolutely powerful. It was very hard for the defense to be able to explain how, especially with the medical evidence, how do you explain a father seeing a child like this on a day-in, day-in basis and doing nothing? And the only reason you would do nothing is because that was your choice not to do it.
Let's see what the defense did, though, in their closing argument, trying to compare that to the prosecution. Remember, this is their attempt to try to explain away the behavior of Zachary Koehn. Let's see how they did. Tough job for a defense attorney here, and Latonia, I imagine it's very tough defending a man who's on trial for the death of his infant son who died from dehydration, malnutrition, and not having his diaper changed for days. Not easy, but how do you think he did in his closing argument?
I mean, I still don't think it wasn't powerful to me. It's still very hard to explain away all of those things you just said, Jesse. But I think the defense attorney did the best that he could do. I think maybe what they were doing in the beginning of the trial that I thought was more effective is talking about the time frame, about when the child could have possibly truly died. I thought that was a little bit better, but it's just very hard. I mean, you know, even trying to explain away the malice part of it, about the child being somebody else's child, I think it was just very hard. It was a very hard place to be in for the defense attorney.
Well, look, we have a lot more to talk about in this case. It should be noted that, yes, he was found guilty of first-degree murder and child endangerment, and we believe that carries with it a mandatory sentence of life without parole. We will report more back about that when we have more information. But let's go to a quick break, and when we come back, a lot more to discuss. Stay tuned. Okay, so I don't even have to tell you. You can see how emotional these people are getting on the stand about this. And Latonia, I'm sure you've seen all different kinds of cases, and I hope you have never seen a case like this because it's so disturbing. What does it do to people, particularly the jury and the first responders who will see the photos, they hear about the events? How does this affect someone's life moving forward? Because clearly there is some traumatic things that happen here.
I mean, it's deeply disturbing. And what the nurse said that is very true just for all of us, even law enforcement, everybody, is when you see something happen to a poor child, because here's the reality, a baby has no defenses. A baby has no ability but to rely on the, caring of the adults that are around it. And it is just so disturbing. And here's the thing too, Jesse, what we are hearing from the witnesses who testified, that's just a small glimpse of what the jurors are seeing. The jurors hear the testimony, but if there are any pictures or any of those things that are not published for everybody else to see, they see it. They see how small this baby was. They see the conditions this child was in. And it is absolutely, it's one of the most powerful things as a prosecutor to be able to show a juror. But it is also, as a juror, I can only imagine one of the most disturbing things that lingers with you. And I think that in itself is the reason why those jurors felt like they had to have justice for this poor baby. And there's just no way for you to explain how Zachary Koehn could, just like the prosecutor said, go in that house every day, see this child in this condition, and do absolutely nothing.
And you know, Latonia, that is one of the reasons that here on Law and Crime we brought this case to our viewers, because it was really important for them to see this and to shed a light on child abuse in this country. We're going to take a quick break. We'll be right back. Let's get some perspective on that video with Latonia Hines, prosecutor here on Law and Crime. Latonia, I'm just going to ask you, because the jury saw that. They didn't talk to anybody after seeing that. You see this. What do you think of it? What stands out to you as you watch that video?
So here's what kind of goes on in my head. One thing I know about jurors, whenever they hear a police officer, at least for purposes of these type of cases, they are paying close attention, because the officer is the investigator at this point in time and giving the details. And so I think what stands out is listening to this interview and thinking to yourselves, what's missing? I think that is what comes into play.
What about the fact that he's holding his daughter and he's being questioned about the death of his younger son?
Oh, yes, but what you build on, too, is this whole idea you care about the daughter, but you don't care about the younger son. The whole thing is just very surreal, especially because you can't isolate the condition the child was in and then his demeanor in discussing the child and the child dying, or in this investigation. It's just very disconnected. It's very weird, because there's no way that if you, just like all of us now, know the condition this child was in, that you would be talking the way that you are to the investigators.
Yeah, the reason I brought that up is because we saw the testimony of Chief Deputy Reed Pallo, who actually questioned the defendant about his daughter, and I want to play that for our viewers right now. So, Latonia, if we believe what the prosecution put forward, that Nala was okay and, you know, Sterling was dead and that this was a deliberate cause here, a failure to provide critical care, you'd have to imagine that he was favoring one child over another. Have you ever seen a circumstance like this?
Oh, yes. I mean, it happens. I mean, it's sad. There's obviously sometimes it's people who have true mental issues. And for whatever reason, one child becomes the target child. Sometimes in child abuse cases, when there's multiple children, there's a child who is the target child who gets most of the abuse. And that happens. And it's not a way to really understand it without going into some type of psychological analysis of it. But with this type of case, like the detective is saying, he saw nothing wrong with the child, Nala. Nala was fine, well cared for. It seemed that, you know, normal weight, seemed like a normal child being able to walk around. And the thing, Jesse, that I go back to, and I think this is what the jurors went back to, the condition of this child, the baby that died, okay? There's no way that any sane, normal person, okay? And let me not even put sane in there because I don't want to say that there's craziness about it, because sometimes people are just not good people. And I think that's the case with Zachary Koehn. Not a good person.
Yeah.
And
I'm sorry. Please continue.
Yeah, and so there's no way that you could look at the condition of this child and think it was okay not to be doing something for it before now.
Right, and I want to expand upon him as a parent, because he was a father of 3, and we never really talk about Caden, his older child who lives with his parents, but we learned a little bit more about that from Willis Koehn, who is the father of the defendant. Let's play his testimony right now. Okay, so Latonia, this is very interesting, but why do you think it was important for the jury to hear this information about Caden?
Oh, it's important to hear this information is because so here's the deal. If you got acknowledgement that the mother may have some mental issues and that this is the reason why the defendant's father needs to take care of the child. So you can't say now, especially when we hear about this information about Nala also, that he's having to step up to the plate to do more for Nala. You knew that there was an issue about making sure these kids were taken care of. You made sure that Caden was taken care of. You took the steps for Nala, but why not Sterling?
Yeah. And that's the key issue.
That is so huge. I mean, this is one of the most disturbing cases that we've seen in a really long time. I mean, just the condition of this poor baby, and what to me shows more malice are these type of facts. These are more malice type of facts. The fact that you would take care of your one son, let your father take care of this child because you have concerns of mother mental issues. And then you take care of Nala. But what is it about Sterling, who is the youngest of all of them, that said that he didn't deserve to have even a tenth of the care that you gave for the other 2?
Yeah, and the jury didn't have any of it. They found him guilty of murder and child endangerment. I do want to let our viewers know something. We're keeping a careful eye on the Armando Baptista case out of Florida. We have a feed we can show you right now. We're waiting to go live into that courtroom. Again, the man who's going to be facing manslaughter charges in connection with the death of Muhammad Knight. We will take a quick break, but when we come back, we might be live in that courtroom. So stay tuned here on Law and Crime. Latonia, I want to ask you a question here when we're listening. If for example, Zachary Koehn was dirt poor, didn't have the resources to take care of himself, any of his babies, was really in a bad place, couldn't get the help that he needed, couldn't get the help that Cheyenne needed, and Sterling died, would that have been a different result, a different outcome in that case?
I think so. It would definitely be a different result. And not only that, I think the charges would be different. We've seen it sometimes in cases with people who have some mental issues or they are slower functioning, and they are trying to do their best that they can to take care of their children. But because of their impairment, they can't do any better than what they're doing. You see something like that happen. But this is not the case here. And if it was the case that it was due to the fact that they didn't have resources or maybe the knowledge of some place to go, then I think the prosecution wouldn't have gone with first-degree murder. We would have a different situation here, but that's not the case here. You have a defendant here who acknowledges for one child that there's not enough care and lets his father take care of him. He takes care of his daughter, but a 4-month-old. This is the part that I think that jurors couldn't get past. 4 months old. Yeah. And this is the condition.
Completely defenseless, completely defenseless. But that didn't mean that the defense didn't try to put on an argument. Let's see some of their arguments in their closing argument. Take a look. Latonia, I'm glad that we're showing this witness because there's a lot to talk about with him. And I don't mean just his hairstyle. That's clearly a given. We could talk about that. But what I really want to focus on is the first thing he said. Do you find it strange that Zachary Koehn never mentioned to him that he had a baby son named Sterling?
Well, I'm not sure how many times people talk about their kids with their drug dealers, but I mean, with, you know, their friends. But what I do find is that you put these all together. You didn't know about his child. His own father had never seen the child in the whole entire time. It just shows the disregard for the child. The other thing in his testimony, guess what? Cocaine is not cheap. Meth, these things are not cheap to get by. But you are willing to get the money and do whatever you need to do to supply your daily drug habit. But doing things as much as changing your child's diaper, you couldn't do it. I mean, that right there, just, I mean, the defense just had a really hard time with this. There's no way to explain this around. And if you notice in the defense closing argument, they spent so much time talking about the mom and the fact that the mom had issues and everything. And so a lot of that, because on some levels, the mother, even though this is unexcusable, we have some documented, at least from other testimony of other people, that she had some ongoing mental issues for a long time. And so these are good defenses for her, but they're not good for him.
Hey, listen, I mean, when we come back from our break, we're going to be talking more about him blaming Cheyenne when he took the stand. But before we do that, I do want to let all of our viewers know that we're keeping a very careful eye on the Armando Baptista case. We're being let know that there is opening statements occurring right now. So let's take a quick break. When we come back, we'll be live in the courtroom. This is a new case out of Florida. You're not going to want to miss it. He is on trial for manslaughter in connection with the death of a father named Muhammad Knight. So stay tuned here on Law and Crime. We'll be right back. Okay, a pretty strong and straightforward opening statement there by the prosecution. We're waiting to hear now for the defense's opening statement, if any. Let's see if I can bring in my special guest, Latonia Hines, to talk about it. Latonia, you're a prosecutor. I thought she did a good job, but I'm curious about you as how she laid down the elements and the facts of this case.
I think she did a great job. The issue for whenever you do this in an opening statement is you've got to make sure that the jurors remember what you're saying in the opening as they're listening to the testimony for purposes of the elements. And that's the reason why the closing argument's the most important thing for summation. Some parts of the thing that's hard sometimes for jurors, and something that, Jesse, you know, we deal with all the time, is dealing with what intent is. And when does intent actually come into play? Or the fact that it can happen very quickly, those elements. And she tried to, I think, hit on that a little bit, like not having to prove that he intended to kill him at that time. You know, she hit on that a little bit, but I think it's very, very important as the prosecutor, when it comes back for that closing argument, you have to go over those elements again and again, because those are hard things sometimes for a layperson to understand. And we can't forget he's charged with manslaughter. How does that differ in terms of prosecuting that charge as opposed to a straight-up murder charge? So manslaughter, I think on some levels, because it's kind of downgraded in a sense, I think it's better for the prosecution. You're not having to show as much, and I don't want to use these terms, you know, in the wrong way for viewers, like malice. You're not having to show that intent as much. It's more of like a recklessness in a sense. Sometimes we talk about that. So some levels it's better for the prosecution because the level of proof is not the same, although it's still beyond a reasonable doubt. Right. That was very well said. You should be a lawyer. Oh, wait, you are, and you're a terrific lawyer at that. And, Latonia, I want you to stand by, because we're going to take a quick break, and when we come back, we might have the opening statement in the defense, but we'll be live in that courtroom. So stay tuned here on Law and Crime. We'll be right back.
Okay, welcome back, everybody. We were just live in the Armando Baptista case out of Florida, and there was a development. The defense said that the state brought up Demetrius Elder in their opening statement, and there was a motion to not bring him up at all in this trial. That was granted. They brought in, and that motion was granted, so they brought it up. There needs to be a mistrial, and the judge just spoke about that. He said the two issues addressed in both motions. The state motions, there's no reference to the conviction of Demetrius Elder, and you remember we covered this case here on Law and Crime. There's no characterization of being not guilty or that case in the defendant's motion, so basically a mistrial was denied. I want to get the perspective from Latonia Hines right now. Latonia, that idea of bringing up Demetrius Elder because he was found guilty of culpable negligence in connection with this crime, why would they not want that brought up in this case? I'm curious, and how do you have a case, how do you have a trial where you don't bring up this man who was intimately involved in these series of events?
Well, I think it's kind of what the judge said. The point is, it's very hard to be able to not bring him up. I mean, he's obviously involved here. The judge there was a ruling about it, but the issue is about what the previous verdict was. That's the reason why you don't want that information in here. It's on some levels prejudicial on both sides, but you don't want that information in. But I think the judge was smart in the way that he did it. I think the prosecution's got to be very, very careful. The last thing you want to do is at the beginning of this trial, it's costly, these trials. The last thing you want to do is go and do anything yourselves to walk yourself into a mistrial. You don't want that to happen. So mentioning the name, but making sure you don't allude to what happened with the trial, it's a very, very hard line to walk on. And I think she's kind of doing it, but I'd be very careful. And I think especially after we've just heard this whole motion and the judge ruling on it, you don't want to go through this again. Yeah,
I don't blame you. But hey, listen, we're not on the jury, so we can know what happened to Demetrius Elder. In case you missed it, this is his verdict back when we covered his case for the manslaughter of Mr. Muhammad Knight. Let's see what happened.
Publish the verdict, please.
In the Circuit Court of the 17th Judicial Circuit in Fort Broward County, Florida, State of Florida, State of Florida versus Demetrius Elder, case number 14-10348, CF-10A, Judge Ernest Cora. We, the jury, find as follows to the defendant, Demetrius Omega Elder. In this case, defendant is guilty of the lesser included crime of coupled negligence. So say we all, it's 27th day of AD 2018 in Fort Lauderdale, Florida, Broward County, four-person jurisdiction.
Okay, so for all of us who are not so sophisticated in the difference between manslaughter and culpable negligence, Latonia, why would a jury in that circumstance find him guilty of that lesser charge?
So culpable negligence is now going down a little bit further from manslaughter, right? The fact that anybody could have done something, a standard of care that wasn't given that a normal person would give, a reasonable person, and that you're going to find that person guilty on negligence. Negligence is below a manslaughter, like manslaughter is below murder. So just so for people to understand that a little bit better. If you are the defense and you had the choice between if you only had two choices for your client, between a manslaughter or something with a negligence, you're going to want negligence because usually in the law, it's a lesser amount of time or punishment.
Yep, absolutely. There's no doubt about that. And maybe the defense for Mr. Baptista here, if they can't get that not guilty verdict, maybe they're hoping for a negligence verdict in the same way, or the lesser charge, maybe that's what they're hoping for. But what we already saw in the courtroom today was the prosecution's opening statement. And in case you missed any of it, take a look. We have some for it. Latonia, we're listening to the defense's opening statement here. Real quick comment from you, if we can, before we sign you off.
Well, here's the deal. I mean, the defense at least already knows what happened before in the other case. I think they're being smart in the way that they're doing their approach. So it's going to be really interesting to see the rest of this. And they're already on it. They have already done some objections during the prosecution's opening statement and some of the statements that they have. So the defense seems to be pretty sharp right now.
Yep, they're arguing self-defense. Hey, listen, Latonia, thank you so much for coming on, and we can't wait to have you back here on Law and Crime.
Sounds good. Thanks, Jesse.
All right, everybody, we're going to take a quick break. When we come back, we'll be live in the courtroom.